would not have capitalized. All right, this is D450187. Counsel, if you'd like to make an appearance.
Yeah. Eric Fletcher, bar number 12370, appearing unbundled on behalf of the plaintiff, Ricardo Aguilar.
Good morning, counsel. Good morning, sir.
Good morning, sir.
And ma'am, if you could state your name for the record.
Jeanette Aguilar,
And you're representing yourself.
representing myself, yes.
Okay, ma'am, he had filed a motion in this matter requesting a number of items. And he said that he had served it to you, it looks like that he sent it out on the mail on the 8th day of October.
Yes,
And you got a copy of that?
yes, Your Honor.
And did you notice on there that, should say, hold on here. Generally within 10 days you are to file an opposition.
Yes, Your Honor.
Was there some reason you did not?
At the time, I don't have the money for an attorney. That's why I'm representing myself, and I was unsure of how to do it. I do have a response here that I would like to submit now, if it's possible.
That would not be possible because under the rules of procedure, you're supposed to follow, whether you're representing yourself or not. However, it appears to me that this matter could be potentially resolved in a relatively short fashion. Your client, in his motion, I believe you're a truck driver, sir?
Yes, sir.
He's indicating, though, he would like to have joint physical custody. That does not appear to be feasible, and he's...
Joint legal,
Yeah, joint legal
Yeah.
for sure. But
well,
the
and then
joint physical
primary physical to defendant.
to the defendant. So there doesn't appear to be much opposition there. And I don't know, as far as he was indicating that there was a business loan of $31.63 and 15 cents. I don't know as far as if they've separated their property, as far as, clothes, furniture. I don't know. Is there a marital residence out there?
There was.
There is not a marital residence in there. You're not part of
So
it.
is there much left over that these parties have?
There's a few things that are disputed, such as the student loans that that she was a part of. That plaintiff feels should not be responsible for, just because of some misconduct surrounding employment. He just feels it wouldn't be right for him to be responsible for them. And then also there's a truck that is disputed as well.
What the court would indicate, student loans, I generally give that responsibility to the person who benefits from the education. For example, the easier ones are somebody goes to medical school or becomes an attorney, they go to law school, and shortly thereafter they get divorced. They want to shackle the other person with half of that responsibility, yet they're the one who's going to achieve the benefit of that education in the future. So that's generally, to give you an idea how to handle that here in court, is the person who is going to derive the benefit from the education would have the responsibility for that. I don't know if it would be helpful, since the two of you are here and you have counsel, if you wanted to potentially take a recess and see what you can do by putting some type of a visitation schedule in order. We could use my standard holiday schedule. They can look at it. If they're comfortable with that, they can put that in place. The two of you can always change visitation or holiday schedules. You could do that by way of a stipulation in order. You wouldn't necessarily need counsel to do that.
One thing that my client would like is he has some, worries with the behavioral, he would almost request a behavioral, or he's got some concerns with bad-mouthing, etc. So he would like to go to FMC to kind of have some specifics agreed upon. And then one other thing is, at this point with his current schedule, he does, understand that she would likely have primary physical custody, but he would like to, if possible, because he anticipates, once he actually fully recovers from a leg injury, having a set schedule here in town. And at that point, he would like joint. And he understands that, the court needs some orders in place now, but since that could be in the relatively near future, he's hoping at FMC they can work out a contingency where he would become the joint custodian when he doesn't have to be on the road as much. Just because he has those, he loves his kids, wants to be there for him, is consistently provided support, has no problem doing that.
All right. this is what the court is going to do. I'm going to send the two of you to family mediation. To the extent that the two of you agree on the custody, the visitation, they will actually prepare all the documents that you need for that order. The two of you won't even have to prepare it. They'll prepare it for you. And they will go over some issues regarding, what do you do for Mother's Day? Generally, mothers get that. Fathers generally get Father's Day. How do you split birthdays? What do you do for Thanksgiving? They'll go through those issues with you. I'm also going to set it for a case management conference on the return. What I'm going to do right now is I'm going to put my standard order for holiday visitation, because we'll have some holidays coming up before we return. So I'll put my standard holiday schedule in place with the caveat, to the extent that the two of you agree in writing, and I would encourage this, you can live beyond that order, because my order may not, it doesn't take into consideration for somebody who's traveling. And so, for example, if he happens to be traveling on Thanksgiving, and my order says that, he were to get Thanksgiving, then you two probably ought to do something to recognize that, all right? The case management conference, what you're going to need to file a financial disclosure form, ma'am.
I have it here.
Okay.
And
I'd like to
plaintiff
see that.
has his as well.
Well, the two of you are going to need to file that, and then you're going to have to provide copies. Once it's filed, do a certificate of mailing, and you'll have to send a copy to the other person. Okay? If you have the same address, I guess you just send it to the same address. So you have different addresses.
He does not, he lives in his truck, so he
Is she
doesn't
able
have a
to send it to
physical.
you even though you're in an unbundled capacity? How should we do that, counsel?
Does she have a copy she could just provide right now, or it's got to be filed first?
Can we just file that in open court?
He's consistently stopping by. He could pick it up.
I'll just file it here, both of them in open court,
Okay.
and then we'll make copies. And that will alleviate.
The other thing is, because my client's willing to have his child support set on the record, and he wants, has been providing support, is continuing to provide support. Just has a concern that he doesn't want his per diem to be taken into account as part of his salary.
I've been using it. I've been going in.
Right now, he's filed a gross or a financial. Wait, hold on. Looks like your client filed one on October 6th.
He has a new job since that time. He has a job that he just started.
On the 12th.
What is the gross monthly income on that?
It's roughly $2,200. He's making $75 a day salary.
2,200. It went down from 5,184 a month.
Yes, because he has the leg injury now. Okay, and that last one also included his per
So
diem.
I'm gonna have you stand up here real quick. Okay? I'm
Yes,
gonna
sir.
Put you under oath. Probably just 2 copies, because.
We have
copies
of ours.
Well, yeah, but this is a file stamp. So.
Okay.
You know what? 3.
You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God. Thank you.
You may be seated, sir. Sir, you originally filed a financial disclosure form on October 6, 2011, indicating that you were a truck driver and that your gross monthly income was $5,184, correct?
Mistakenly so, yes. My job is a phone call, change in a second. I haul entertainment around the country, staging, lighting, concert tours. I didn't understand that form, and I was in a big hurry to file it and fill it out. So I included everything, including my per diem, which when I did this one and I looked at my receipts over the last year, how I live, I've actually gone into my per diem to provide for my kids, and that's left me short on what I need to live on the road. And so I made a mistake on the first one. At that job, I got $70 a day. Now I'm getting $75 a day, and the per diem's the same. And I have my bank statements showing what I've paid out.
Do they pay you by, how do you get paid?
It's a salary, and every 2 weeks I get a check, and on there you'll see that the 75 times 13, that's the days, not hours. And then you'll see below there the
He
650.
doesn't have it on him.
Oh, I'm sorry.
I don't have a copy of what you filed right now.
Do have another copy of the pay stub if you want to look at it.
Is that the,
This is the same one that they just took off the copy.
yeah, let me see it here real quick.
I tried to get the second pay stub, but I was out of town and I couldn't download it off the internet.
And she hasn't, from what I understand, the defendant understands that this is what he's making. She's not challenging this as well. He's willing to provide the support. Supposedly, he has been providing the support, and he's willing to continue it. So,
And this one here is for a new employer, or is it?
Yes, sir. With my knee injury, I'm pretty lucky to even have a job. And again, it isn't over the road, out of town, doing the same stuff as I was doing before, but they're a more stable and stronger company than I was with before. And so I do get paid on paydays, which is nice. And
So you get paid 75
a day.
a day. So is this for a 2-week period then?
Yes, sir.
All right, what the court is going to do on a temporary basis, 25% of the 2,200 that you're claiming you get a month is $550 a month. I'm going to order that, have you been paying anything, sir?
Oh, it was, you betcha.
You have been paying.
I have records.
yes, he has been paying consistently. Not specifically in a set check, as dictated as child support, asking for, some of her
I've
bills.
been paying her
et cetera.
$300, $600 a month out of a bank transaction.
All right, the court is going to order that you pay the $550 starting on December 1st. This is going to be without prejudice. You're going to have to provide probably by our return date, I would have you provide your biweekly statements up until the return date. We'll look at that again and see where things are at to see if it's consistent as far as what you're making. And then I'm going to refer again the two of you. You have your financial disclosure form. There is a co-parenting class that the two of you are going. Have you taken that, sir?
I want to.
Okay, well, you're going to have to take that. Ma'am, you're going to have to take it. We'll give you the information. I'm going to request that you do that within the next 30 days. You can do it online, or if you're here in town, sir, you can do it here in town. They'll give you information on that. Okay, that is a requirement. I'm going to set this over for a case management conference. What I'd like the parties to do is, before we return, is to file something out there that would indicate if there's any debt that you're requesting, to put that debt out there. If there's any assets that's out there as far as retirements, if there's any bank accounts, savings account, all that information, you're going to have to put that out there. Additionally, if there's any disputes as to vehicles that you want the court to consider, if there's vehicles, if there's furniture, any of those items, you can put that on there, and we can address this when we come back and possibly have the two of you divorced and not have a lot more fees on this as far as attorney's costs and fees. The return date on mediation will be
February 23rd at 8:30.
Sorry, what was that?
February 23rd, 8:30.
okay. I'm also going to put in my standard behavior order in place, and essentially what that means to the two of you is that the two of you are going to foster a good, healthy relationship with the children and the other parent. That means neither of you are going to make any disparaging remarks. Neither of you are going to, bring up issues about the other parent and their past. That you're not going to, interfere with the right that the two of you have as parents to enjoy a good, healthy relationship with your children. You understand that, ma'am? And you understand that, sir?
Very much so.
And what I would tell the two of you, to the extent that children have good relationships with both their mother and their father, whether or not the two of you are living together or not, they tend to be, healthier, happier children, and they tend to, mature into happier, healthier adults. When, parents have issues, relationship issues with their parents, the people that they should love the most, it causes problems in their lives. So I'm just telling the two of you that you need to, in spite of the fact that the two of you may now have your differences, you need to make sure that your children have the best life possible, and that includes having a good relationship with the two of you. Okay? As to right now, then, the court is going to defer to the other issues on custody, on visitation, to when you come back. I'm going to put my temporary holiday schedule in place. Is there some reason why, until we come back in February, that the two of you are not able to just to continue what you've been doing regarding visitation?
We have been a little bit concerned with when we do set up, we have been trying to work with it, that she doesn't always acknowledge our agreement. We would say that he's going to come over to spend time with the boys when he has time, and she's requesting more and more notice that he can't provide with him being on call so much. And then when he is in town, he is calling, and he's worried that she keeps changing her mind, or she's not available, or she won't give him time with the boys when he is available.
Ma'am, in that regard?
When he does give me the notice, but when he calls me he doesn't say, okay, I'm here in town, I'd like to see the boys from such and such time to such and such time. Lately it's always been just about what's going to happen in court, and it's mostly just talking to me. And when he has spent time with the children, he has no place to visit with them, and so I have let him come over to the apartment that I got after our home foreclosed, and he, to spend time with the kids, but I'm uncomfortable with him being in my home, and so I would like, if he's going to take them, he needs to have some place to visit with them other than the park across the street. Or
Do both of you have cell phones?
yes.
Are you able to text each other?
Your Honor,
Hold on. Are you able to text each other?
yes.
Okay. Seems to me that he should be able to make arrangements. And when you stay in town, sir, where do you stay at?
In my truck.
Okay, in your truck.
And that's very hard for my kids. I got accommodations for them, but with this company, I'm not allowed to travel with them. So I'll pull into the park, and they're welcome to come inside. I've recently, because of this, set up a speaker so that we can watch a DVD in the laptop together, as well as I can cook food in there. But my kids really don't want to be cramped up in a truck.
All right. Is there... there's a number of things you could do, sir. First of all, maybe having a visit at a public library or something where the kids aren't crammed up in a truck and you could, go there. You could potentially take them, right now it's wintertime, so you don't want to probably be outside in a park right now, but, you have malls there. Your kids are, 12 and 9? There's, even going to, maybe there's another option, but, something like a Chuck E. Cheese or somewhere, or even, a a restaurant or somewhere where you could sit down and have a meal with them and spend some time with them. Seems like maybe the option of going to a library and just seems like to me that would be some options that you'd have available.
And that is what I'm working for, but whenever I've scheduled something like that, Your Honor,
Okay, then what I
it's
would
been
do,
changed
all
because
right,
of the pickup.
all right, what I would do, sir, is when you're aware of your schedule, with as much time possible in advance, that you would text her and let her know that you're going to be in town and then you'd like to visit with the boys. Ma'am, if he sends over a reasonable request and is texted to you, I would expect that you would send him a text back confirming and that, that it would, his reasonable request would be granted. My guess is they're going to be sometime after the kids, if it's not on a weekend, it'd be after they got out of school and, have them in time and home to do their homework and to be in bed at a reasonable time. If it's on a weekend, that would be a different type of a situation. So I'm anticipating that, especially over this holiday season that we're coming up, that they're going to be able to see their dad. You understand that, ma'am? Okay. So you can put that in the order, counsel, as to do that. And if you send over a reasonable request, sir, on your text, and she doesn't respond to you, or she doesn't, then you can have those, copied or printed out, or do something where you can bring them into court and say, look, here's the time, this day. I said, look, I'm going to be in town. You can bring that in, and we can address it. I'm hoping that the two of you may be able to address this by way of, you're going to mediation, and the fact that you may be, at least on a temporary basis, on some type of a disability, sir, where you're not going to be driving, that would, if you're here in town, that would probably make it a lot easier also. So, that being said, we will see you back here on
February 23rd at 8:30.
May I
Yes.
ask one more? Another issue is, am I to continue to carry health insurance on him?
the two of you are married, so that means until the two of you are divorced, you're still married, so you can't unilaterally take him off health insurance
Until after February.
until after you're divorced, okay? If there's any other issues that you want to address on a temporary basis, ma'am, on a return date, you'd have to file some type of, opposition to his motion that would allow me to address issues. You can't just come into court and, bring up new issues, okay? So that being said, counsel, if you could prepare the order from today, and we will see you back here in February.
I want to have my niece, I'm going to be working for this